Hello. Today we are here to discuss the drug guideline found at 2D 1.1 in the Guidelines manual. This is the first of a two-part tutorial on the drug guideline. During this tutorial, we will focus on the overall structure of the drug guideline, its key application notes, a discussion of the drug quantity table, and the drug equivalency tables, as well as a discussion of special rules to be applied when determining quantity for certain controlled substances such as LSD, marijuana plants, methamphetamine, and a few other drugs. Let's begin our program by looking at the overall structure of the drug guideline. One of the first things you will notice about 2D 1.1 is that it has multiple base offense levels, and the court is directed to apply the greatest. Increased base offense levels are provided for defendants who are convicted of drug offenses in which death or serious bodily injury has resulted from the use of a drug, and the defendant has prior convictions for similar offenses. For defendants who are not convicted of offenses in which death or serious bodily injury has resulted from the use of a drug, the base offense level is determined by the type and quantity of the drug involved in the offense. Those defendants' base offense levels will be determined pursuant to 2D 1.1A5, the mitigating role cap. Please be aware that if the defendant receives an adjustment under 3B 1.2 for mitigating role, that defendant's base offense level will be capped between 30 and 34 accordingly.
Now let's take a look at the drug quantity table. The drug quantity table found at 2D 1.1 subsection C provides base offense levels for a number of controlled substances that are referenced in the statute at 21 U.S.C. section 841b1. The statute provides directions only for the more common controlled substances such as heroin, cocaine, PCP, methamphetamine, LSD, fentanyl, and marijuana. Base offense levels start at 6 and increase to 38 depending on the type and quantity of the controlled substance. As you can see now, these are the base offense levels for cocaine. Historically, base offense levels have been linked to the penalty structure provided in the statute at 21 U.S.C. 841b1. For example, offenses for which the statute prescribes a mandatory minimum penalty of 5 years or 60 months, the quantity that triggers that 5-year penalty is assigned a base offense level of 26. This corresponds with a guideline range of 63 to 78 months for a defendant in criminal history category 1, thus encompassing the 60-month mandatory minimum required by the statute. Offenses for which the statute requires a 10-year mandatory minimum, or 120 months, the quantity that triggers the 10-year penalty is assigned a base offense level of 32. This corresponds to a guideline range of 121 to 151 months for a defendant in criminal history category 1, thus encompassing the 120-month mandatory minimum required by the statute.
The guideline at 2D 1.1 also contains notes to the drug quantity table. These notes provide specific rules for certain controlled substances to guide the court in determining the quantity of drugs to be used to determine a defendant's base offense level. We will talk more later about some of those specific rules in the notes to the drug quantity table. As with all the guidelines in the Guidelines manual, there are application notes at 2D 1.1 that provide necessary guidance for the court in determining a drug defendant's offense level. I would like to point out here that a 2012 amendment to 2D 1.1 has reorganized the application notes to the guideline, making them parallel with the guideline and more user-friendly. The first application note we will discuss will be 2D 1.1 Application Note 8, also known as the drug equivalency tables. Application Note 8 provides equivalencies for controlled substances not listed on the drug quantity table. If you have a case involving a drug that is not listed on the drug quantity table, you will need to consult the drug equivalency table in Application Note 8 to find that drug's corresponding marijuana equivalency. For example, let's say you have a defendant who has been convicted of distributing 50 grams of MDMA, MDMA is not listed on the drug quantity table. Therefore, you will need to consult the drug equivalency table to find the marijuana equivalency for MDMA. Application Note 8 provides that 1 gram of MDMA is equivalent to 500 grams of marijuana. In our example, we have a defendant convicted of distributing 50 grams of MDMA. Multiplying 50 grams times 500 grams will give us a total of 25,000 grams or 25 kilograms of marijuana. We will now take that amount, 25 kilograms of marijuana, and determine the defendant's base offense level according to offense levels on the drug quantity table provided for marijuana. According to the drug quantity table, for an offense involving at least 20 kilograms but less than 40 kilograms of marijuana, the base offense level is 18. Thus, our defendant convicted of distributing 50 grams of MDMA will have a base offense level of 18.
The drug equivalency table must also be used in any case involving more than one drug. Even if one or all of those drugs are listed on the drug quantity table, the court must convert them to marijuana and then add the quantities in order to determine the base offense level applicable to all the substances. Let's go back to the example we just discussed in which the defendant was convicted of distributing 50 grams of MDMA. But let's say that as part of the conspiracy, the defendant was also responsible for distributing 150 grams of powder cocaine. We already know that converting the MDMA to marijuana gives us a total of 25 kilograms of marijuana. However, now that we have an additional 150 grams of powder cocaine involved in the offense, we must also convert the powder cocaine to marijuana. Application Note 8 to 2D1.1 provides that 1 gram of powder cocaine is equivalent to 200 grams of marijuana. Multiplying 150 grams by 200 grams gives us a total of 30,000 grams or 30 kilograms of powder cocaine. We then add the 30 kilograms to the 25 kilograms for a total of 55 kilograms of marijuana. According to the drug quantity table, for offenses involving at least 40 kilograms but less than 60 kilograms of marijuana, the base offense level is 20. The addition of the powder cocaine moves our defendant from a base offense level of 18 to a base offense level of 20 for the combined quantity of the controlled substances. The next application note we will discuss is 2D1.1 Application Note 6 that addresses analogs and controlled substances not referenced in the drug guideline. If you have a case involving a drug that is not listed in the drug quantity table or the drug equivalency table, you will need to look to 2D1.1 Application Note 6 for guidance in determining the base offense level for your defendant.
For example, many of you may have heard of a new controlled substance known as bath salts. Bath salts were recently placed on an emergency schedule by the Drug Enforcement Administration and as a result are not referenced in the guideline at 2D1.1. If you have a case involving bath salts, 2D1.1 Application Note 6 advises the court to consider several factors to determine what is the most closely related controlled substance referenced in the guideline at 2D1.1. Those factors include 1. Whether the chemical structure is similar to the controlled substance, 2. Whether the substance has a stimulant, depressant, or hallucinogenic effect on the central nervous system that is substantially similar to the controlled substance, or 3. Whether a lesser or greater quantity of the substance is needed to produce a substantially similar effect on the central nervous system as the controlled substance. Let's turn our focus now to the notes to the drug quantity table. These notes can be found immediately following the drug quantity table at 2D1.1 subsection C and provide specific rules for determining the base offense levels for certain controlled substances. We'll highlight a few of those now. The general rule for determining the quantity of a controlled substance is found in Note A and provides that unless otherwise specified, the weight of the controlled substance refers to the entire weight of any mixture or substance containing a detectable amount of the controlled substance. Note B, however, provides several exceptions to this general rule. for PCP, amphetamine, methamphetamine, the court will instead determine the actual weight of the controlled substance contained in the mixture or substance, and then compare that with the entire weight of the mixture or substance and use whichever weight is greater. The actual weight of the controlled substance is also used in cases involving oxycodone. However, there is no need to compare the actual weight with the entire weight of the mixture or substance and use the greater. Note D advises that the term cocaine base in the guideline means crack. Note E directs the court that in the case of an offense involving marijuana plants, each plant is to be treated as the equivalent of 100 grams of marijuana. Note G provides that in the case of LSD on a carrier medium, the weight of the carrier medium is not to be used to determine the entire weight of the mixture or substance.
That concludes this part of the discussion on the drug guideline. Stay tuned for the second installment of this two-part tutorial. If you have any questions about 2D 1.1 or any of the other sentencing guidelines, please look to our website, www.ussc.gov, or you can call the Commission's helpline at 202-502-4545. Thank you.